Throughout our investigation into Tsai Ing-wen's academic dishonesty, one thing has become abundantly clear. LSE and the University of London are cooperating with the cover-up. Despite revealing that Tsai Ing-wen started teaching at Soochow University in 1983, that the thesis title on her employment record did not reflect the one she had been peddling, and that she had bypassed examination protocol to garner work, Tsai Ing-wen and her people continue to wage cognitive warfare using the judicial system to keep her opponents in check. To combat the litany of lies and misinformation that Tsai's people shell out, ThesisGate investigators spent over a year and a half pouring countless hours into litigating the wrongdoers. Investigators' commitment to the truth have proven worthwhile, as Tsai's people have been caught in contradictory statements revealing their lies. On November 26, 2021, the LSE Council announced that it did not have information on Tsai's Viva in an effort to sever the school's ties with the criminals. In the past, LSE chose to stay quiet, but now they have decided to cut ties with Tsai Ing-wen. Investigators now set their sights on the University of London in hopes of revealing more truths. Since September 4, 2019, the presidential office has relied on several documents and statements supposedly taken from LSE to convince the public that Tsai's education is legitimate. However, an ICO ruling containing the LSE Council's declaration renders all of that material useless. One of the things Tsai's team has relied on the most is a statement from LSE published to its website on October 8, 2019. However, this statement should be taken down since the LSE Council has said it does not have records on Tsai's Viva, meaning it cannot definitively endorse Tsai Ing-wen's PhD. Of course, LSE must explain how this statement came to be. The information behind it could have come from the University of London. That would still make it valid. On December 3, 2021, Dr. Huan Lin wrote to LSE's Kevin Haynes, citing the Freedom of Information Act, and asked 4 important questions. Number 1. Did an interfering third party write the October 8, 2019 statement on the LSE website? Number 2. If not, did the statement come from the University of London? 3. If not, did the statement come from the London School of Economics? 4. If so, who or what department at LSE wrote this statement? Unsurprisingly, Kevin Haynes responded to Dr. Lin on December 9, 2021, calling the email vexatious and refusing to answer his questions. However, over the past 2 years, a few vigilant viewers had already posed Dr. Lin's questions on whatdotheyknow.com. LSE Information and Records Manager Rachel McGuire, who also happened to be on the same legal team as Haynes, responded to them. She rejected the inquiries, also calling them vexatious. Anytime there is a request for information, investigators are met with rejection or attempts at diversion. There has never been a straight answer. Of course, Dr. Lin is very familiar with the website statement. As early as October 9, 2019, he sent emails to school libraries asking them to validate LSE's website statement. They couldn't. The thesis that the website statement said was entered into a library referred to a book that someone attempted to smuggle in 2011. IALS ultimately rejected it. Clearly, someone is tampering with information. Even today, many Tsai Ing-wen supporters continue to spread the LSE statement as if it can definitively attest to the truth. Unfortunately for them, LSE website's Terms of Service Article 2.8 says, "We do not necessarily endorse nor are we responsible for the accuracy or reliability of any opinion, advice, or statement made on the website." Article 2.7 says, "Any opinions, advice, statements, services, offers, or other information or content expressed or made available by third parties, including information providers or users, are those of the authors or distributors and not of us." No one dares say whether the website statement came from LSE or not. This refusal indicates that Rachel McGuire and Kevin Haynes are not just LSE administrators. They belong to an organization that is cooperating with Tsai Ing-wen's people. Furthermore, one of them once claimed that Tsai Ing-wen's vivo took place on Sunday, October 16, 1983. The other one claimed that Tsai's examiners were Michael J. Elliott and Leonard H. Lee. Both claims ultimately led to Prosecutor Huang Wei pressing charges against Dr. Dennis Pang. As a LSE legal representative, Kevin Haynes knows that if he answered Dr. Lin's questions, it would draw a lawsuit from investigators. There is no doubt that both Haynes and McGuire are caught up in ThesisGate's deception. They will not divulge any truths. Investigators will not only file ICO motions against McGuire and Haynes, but will also take them to court as well. Haynes and McGuire aren't the only ones at LSE cooperating with Tsai Ing-wen. They're merely in charge of outgoing information. So who is providing Taipei prosecutors with forged evidence from the school? Who are the ones orchestrating this scheme? On March 10, 2020, Tsai Ing-wen's lawyer Lien Yuanlong made a request for evidence. Such a request should have been made to Prosecutor Huang Wei and the LSE archives. Aside from keeping historic files dating back to 1895, LSE archives also contain staff and student files. The plaintiff, Tsai Ing-wen, formally applied for such documents on September 3, 2019, receiving over 200 pages of files. 12 documents taken from that file were provided as proof. As mentioned before, the offending party can't say any documents pertaining to Tsai Ing-wen came from Tsai herself. Otherwise, Tsai Ing-wen would be liable for getting called on as a witness. If that happens, she would immediately become a suspect in any ThesisGate lawsuit. That's why national security organizations explicitly say they obtained files from LSE archives, to keep Tsai Ing-wen out of this. Even so, Lien Yuanlong's initial request is full of holes. First, on September 4, 2019, the Presidential Office spokesperson's office published Tsai Ing-wen's student record on Facebook. According to the request, it obtained that document from London in one day. Even if the document was placed on a charter jet, it would have been impossible to get something from London to Taiwan that quickly. The only possibility is that the spokesperson's office acquired a digital copy of the student record via email. That also explains why all of Tsai's other education documents are photocopies. They're not original, meaning they don't have any legal standing. The reason why the offending organization didn't disclose that the documents were taken from digital files is because it didn't want people asking questions. If Tsai Ing-wen wants to use these digital documents as a basis for legal action, then she should disclose how they came to be. Second, why did Tsai Ing-wen apply for the documents on September 3, 2019 from the LSE archives? Why didn't she just request documents from a more conventional source, like, say, the University of London Transcript Office? Who suggested that she get files from the LSE archive? If someone wants to get a replacement diploma, wouldn't it make more sense to go directly to the office that produces diplomas? A normal person would always go to a diploma office first if they were looking for a legitimate degree. This story about how Tsai went to the LSE archives is just an attempt to fool the people. Third, besides trying to muddle the origin of the student record and diploma, the offending party also wants to obscure its acquisition methods. They said that they requested documents for the purposes of comparison and not to authenticate. So long as the offenders could access LSE archives and get their documents placed there beforehand, then, of course, whatever they had would match up with the official records. After all, who would notice if signatureless documents got into the archive? This is also why Tsai's people could get their hands on the files just one day after applying for them from the archive. We can practically be sure that someone at the LSE archive is helping out Tsai's cause. Fourth, the biggest problem with this story is why would Kevin Haines agree to help Taiwan's UK representative office to acquire files from the LSE archive? He already once said that Tsai's 1984 diploma would be on file with the University of London Transcript Office and that the representative office should be getting it from there. The only explanation is a 1984 signed diploma would be a legal document, and the inclusion of that in ThesisGate files would have grave ramifications. So it's again time to ask the presidential spokesperson's office, where did it get the September 4th, 2019 student record from? This isn't the only blind spot in national security organizations' stories. Let's dial the clock back. Why is it that Tsai's Viva notification memo and the letters from PC Kennedy each have 3 different versions? This is not a mistake. This was a precise move conjured by the presidential office and the LSE legal team in order to mitigate legal responsibility. All of the other education documents shown so far are run-of-the-mill records. They don't have any legal implication one way or the other. They are of no concern. However, the offending organization shuffled many of these inconsequential records in with degree-relevant documents in order to normalize the LSE archive story. From Lien Yuanlong's court files, we can see that the version of the PC Kennedy letter he sent out did not have a signature. LSE archive having signatureless documents is normal because an archive should possess general records. That's why Kevin Haines had no problem putting LSE archive documents on the line. In Xavier Chang's lawsuit, Lien Yuanlong brought out the PC Kennedy letter that the Education Ministry provided. Huang Wei still used it in his case. Not only does Huang Wei refuse to investigate Tsai, he's become an accomplice in this scheme. Even after realizing there were problems with the evidence at hand, he still pressed charges against Dr. Dennis Pang. Such an elaborate plan only proves how much the offending party is willing to push legal boundaries. Despite having her lies unraveled and revealed, Tsai continues to stay quiet and play dead. The key to finally breaking ThesisGate lies in undoing the extensive cover-up in London. The most crucial element to break here is the ICO's June 11, 2020 ruling, which reinforced the University of London's position to protect Tsai. The ruling said that the University of London did not need to publicize who Tsai's examiners were. That prompted Michael Richardson to lodge a series of complaints. That's how Richardson got LSE counsel to admit they did not have Tsai's Viva records. The ICO's June 11th ruling not only led to one key tribunal court case, but three. One of them was initiated by a Taiwanese American business leader who also took issue with the June ruling. On December 18, 2021, the tribunal issued a ruling that rejected the University of London's explanation that it lost Tsai's thesis. We accept that the explanation originally provided by the university that the thesis had been lost or misshelved may not be correct, as there is no catalog or microform record of the original thesis. Unfortunately, the tribunal does maintain that this does not mean that President Tsai was not awarded a PhD degree or that there has been academic fraud. Just like with Richardson's ruling, the tribunal could only evaluate information given by both sides. Judge Hazel Oliver held a hearing. Dr. Dennis Pang joined virtually. Dr. Pang showed a video of him traveling to IALS and Senate House Library to search for Tsai's thesis. Dr. Pang successfully convinced the judge that the University of London's initial evaluation of the situation was erroneous. Unfortunately, the tribunal does not have any investigatory privileges, so it had no choice but to accept an alternative explanation from the University of London, which was that the school had files on Tsai Ing-wen's Viva and her degree conferment. In the end, the tribunal ruled that the University of London still did not have to provide Tsai Ing-wen's information, indicating that much higher powers are necessary to bring this scandal to justice. The interesting thing is that when asked their opinion, the judge said that they didn't think the school was telling the truth. However, the judge said that they couldn't outright say the school was lying. It's abundantly clear that the University of London said it claimed it lost Tsai's thesis between 1980 and 2010 in order to steer clear of the 2011 smuggling incident. These two tribunal rulings allow us to observe the UK's traditionally conservative culture. It also gave the investigation team a deeper understanding of how the tribunal courts work. With this new experience, ThesisGate investigators have a clearer idea of how to move forward. There's a clear roadmap for getting the October 8, 2019 LSE website statement officially pulled. Over the past few years of investigation, the criminal organization has refused to concede. The biggest contributor to ThesisGate investigation efforts in Taiwan is none other than Zhou Yuxuan, the judge who has been placed on parental leave. Through deduction, it's clear that Huang Wei and Kevin Haines connected between June and July 2020 to lay out their plans. They exchanged their versions of the PC Kennedy letter, which allowed Huang Wei to make bold claims to the media and formally charge Dr. Peng on March 31, 2021. If this were the only side of the story, then it's fair to say that investigators have been fighting a losing battle. But in November 2020, Judge Zhou Yuxuan did order the acquisition of evidence from London in Dr. Peng's case against Xavier Chang. Aside from ordering Huang Wei to hand over the evidence he had on hand, Judge Zhou made one very crucial decision, and that was ordering the acquisition of testimony from LSE. One of the questions included in the testimony was Dr. Dennis Peng's, who were Tsai Ing-wen's examiners, something the University of London refused to answer. Shortly after that, Kevin Haines came forward with his 278-page record, which said Michael J. Elliott and Leonard H. Lee were Tsai Ing-wen's examiners. Those claims were what allowed Richardson to garner consecutive wins in the tribunal. All of the developments we've obtained today are thanks to Judge Zhou. What happened after that is familiar news. Zhou Yuxuan was placed on parental leave for 1.5 years. The case with Xavier Chang has seen 3 different judges so far. The person manipulating the justice system isn't going to have a change of heart anytime soon. Judge Li Xiaofen, who now handles the case, didn't plan to have a pretrial hearing. Instead, she planned on going straight to trial on December 6, 2021. In that event, Jim Chang added more charges to the case. Namely, he accused Chang of publishing false information in government documents. After all, press releases are official documents. Because the potential penalty was now a minimum of 7 years, Lee had to call a judicial panel on November 15, 2021, with 3 judges in attendance. During that hearing, Lee's attitude was rather hospitable and patient. She said that because the plaintiff's lawyers provided comprehensive statements, she had no further questions. She said that because of this, it wasn't necessary to have Dr. Peng video call in to answer any questions. The ironic thing is, in Tsai Ing-wen's defamation case against Dr. Peng, Judge Yao Nianci said there was no need for live streaming in the courts. However, after that, Judge Yao and prosecutor Liu Cheng-wu were dissatisfied that Dr. Peng wasn't in attendance despite saying he couldn't stream in. They even issued a warrant for Peng's arrest. Returning to the November 15th pretrial hearing, both sides submitted supplemental statements. The defense included evidence left over by prosecutor Huang Wei. Shortly after noon, Judge Lee said she was ready to end the hearing. Jim Chang immediately pointed out that the court had skipped over witness summons. Just like Yao, Lee refused to address the witness issue and kept saying time was up. She said that it had been a hard day's work and that people needed to rest for lunch. Lawyer Li Zhenghua protested, saying that neither side had a chance to apply for witness summons and that the procedure wasn't complete. Judge Lee said that the matter would be sorted out via standard administrative procedure. It seemed that the judge was going to prevent the plaintiff from calling Tsai as a witness, so Lawyer Lee motioned to continue the unfinished procedures on December 6th. Under lawyer Chang and Lee's insistence, Judge Lee relented and agreed to the proposal. However, come December 6th, Judge Lee immediately skipped over continuing November 15th procedures. Li Zhenghua immediately objected and reminded the judge of what she had agreed to in the last hearing. He insisted that the court deal with witness summons before moving on to trial. Li Zhenghua described the current status of the case and warned the judges against holding an improper trial. He then brought out the ICO's November 26th ruling. Jim Chang then said he wanted to add Presidential Office Public Affairs Director Zhang Wenlan to the list of defendants because Presidential Office press releases need Chang's approval before going on. In order to do this, Judge Lee needed to revert the court to pretrial procedures. At this point, Judge Lee turned to Xavier Chang and asked who approved the president's press release announcing Tsai's intention to sue. Chang said he wrote and published the release. Seeing no choice, Judge Lee agreed to Jim Chang's terms and reverted to pretrial proceedings. Just as the trial was about to finish, Chang's lawyer reminded the judge that she ordered Tsai's 2015 diploma to be tested during the last meeting. Judge Lee agreed and began inquesting the document. Once finished, she handed the document to Jim Chang and Li Zhenghua. After 10 minutes of examination, Jim Chang asked why there were two reissued diplomas, both with embossed seals. He asked why neither diploma had the dean and director's seal, which were required to be valid. Xavier Chang said that wasn't correct. He said the 1984 diploma didn't have the seals. Jim Chang simply told Xavier Chang that the 1984 diploma is fake too. Jim Chang asked the judge to have the University of London validate and verify Tsai's diploma. Xavier Chang's lawyer then said that Tsai's diploma was not what was on trial. He said the diploma had long been authenticated. There was no need to send it to the University of London. Jim Chang said that the diploma on display could be purchased online. Li Zhenghua asked the defense to submit Tsai's application for the replacement diploma. He pointed out that the envelope the diploma came in did not have an address or name on it, indicating it was not mailed. All the evidence showed that President陈水扁was right and that Tsai got the diploma from Lord Giddens. Li asked to summon President Chen as a witness. At a loss, Judge Lee dismissed the court. It's very clear that someone is manipulating the judicial system behind the scenes. It's just as Jim Chang said, every judge that has handled the case has done so improperly. Not a single judge has made justice a priority, including Judge Lee. As a reminder to the judges, anyone who plays a role in this cover-up will be punished. You cannot deter ThesisGate. You can only stoke the conviction fueling it.